Okay. So did you hear
I
my?
hear.
Okay, so what I said about we're recording right now. Okay. So so as I said, so good evening, and a little bit about our CPAG. For those of you who don't know, our CPAG for Old Bridge has been up and running for 8 years now, and the mission of our CPAG is to really build collaborative relationship with the school district, with administration, with our Board of Education, also about empowering our families and our parents to understand their rights in special education and to be able to effectively advocate, and also around inclusion and inclusive practices. And we also have a very strong presence on social media, and we really do involve ourselves in all of the meetings and really make sure that our CPAG has a seat at the table when decisions are being made that impact students with disabilities in our school district. So with that said, I'm going to introduce this evening Lisa Hernandez. And let me just read a little bit. Lisa is an attorney and parent of a child with disabilities. Lisa holds the position of counsel at Smith Eibler LLC in Homedale, New Jersey, where she leads the firm's education law practice. She focuses her practice on helping families and students with disabilities navigate special education disputes, school-based accommodations, and transition planning. Lisa also practices plaintiff side employment law, representing individuals in all aspects of employment law and litigation, including disability discrimination and retaliation. Seeing firsthand through her practice how frequently individuals with disabilities struggle um, to receive reasonable accommodations in the workplace, Lisa sees the importance of assisting students with transition planning, college accommodations, and understanding their rights under federal and state anti-discrimination and equal access laws. Preparing students with IEPs for life after high school is one of her driving passions. Outside of work, Lisa is an attorney member of the Council of Parent Attorney and Advocates and a founding member of her own school district's Special Education Parent Advisory Group. Her thought leadership has appeared in several publications, including New Jersey Lawyer and Inclusive Education Project podcast. We are so pleased and honored to have Lisa here this evening, and I can't say enough great things, and it's been a pleasure getting to know you over the years, and I'm so proud of the work that you've been doing. So
Okay.
thank you so much. Over to you now, Lisa.
Thank you. Thank you for having me. Stephanie and I first met each other when I live in Mountainside. My office is in Homedale, but I live in Mountainside. And when we were first trying to get a CPAG up off the ground several years ago. So that's how Stephanie and I first met. So I'm going to go ahead and share my screen and we can get started. Okay. Can we see? Can I get a thumbs up? Thank you, Stephanie. Okay. Okay. So we're going to talk today. I understand everyone is kind of having a little trouble these days, and you guys are not alone in how school districts are dealing with certain disciplines in response to behavior. And so we're going to address that today. I can't toggle. Give me a sec. Trying again. Okay, I might have to leave it a little bit like this because of the toggling issues. Can you guys see? You can? Okay. All right. So this way I can just click the slide as I go. Okay. So just a brief so we're going to talk first about changes in placement due to behaviors, informal removals, missing out as discipline. That's when your child isn't allowed to go to recess or isn't allowed to participate in gym or at lunch. We're also going to touch on classroom clears, seclusion, and restraint. This isn't always a highly requested topic. I'm going to talk about it, and I always want to talk about it in the context of behavior and discipline because it happens a lot more often than parents. Parents don't always have to be informed if it's happening. And it is underreported, generally speaking, school districts throughout the state. And then we're going to talk about some actionable ideas for parents, and then we'll get to your questions. So let's talk about changes in placement as a response to behavior. This can be a change in placement that either, and here we're generally talking about have IEPs, but we can talk about functional behavior assessments for students who do not have IEPs. It's an evaluation. It can be either a change in placement that a district wants to implement or that a parent is requesting. A change in placement doesn't have to mean a student moving from to a different type of classroom. It doesn't have to mean a student leaving general education to go into an LLD classroom. It can mean being a one-to-one para for part of the day. That would be a change in placement because it's actually just a change in services. So anything on that IEP document on the front page, bottom right-hand corner, if it goes in there, if it's listed there, that's your child's placement. Box, just as a general rule of thumb, could be considered a change in placement. So we're going to talk about functional behavior assessments, or FBAs, the resulting intervention plans, sometimes you hear them called BIPs, and we're going to talk about fidelity data and prior written notice. So FBAs and BIPs. So change in placement requires some type of data to support that change. There has to be a reason, and it should be an objectively provable reason. That isn't always going to be the case. Sometimes parent and district just agree that something needs to change, and so you try something out. There's nothing wrong with that. More hard, objective data you have to support a change, the better. Whether you're the parent requesting it and you're getting pushback from the district, or the district wants it to happen, and you as the parent have questions about the appropriateness of that change. So when the change is being suggested as a student's behavior, you need behavior-based data. And that's where the FBA and the BIP come in. So you get the data in FBA, and then the BIP is kind of a roadmap about how to address the behavior. And an important note that I like to mention here is that a lot of school districts, a lot of us, see behavior as a matter of volition, right? It's will. It's a strong. The student doesn't want to participate. They don't want to follow directions. And so we seek to control it. We seek to control the behavior and subdue the behavior. But I want to suggest to all of us that behavior is not necessarily an act of volition. Behavior is a skill, and it can be taught. And sometimes our children, if they have a disability that then manifests in maladaptive behaviors, or if they have a behavioral-based disability, they need sometimes explicit instruction or modeling in how to develop behavior skills. And so that's kind of the framework that I'd like us to all keep in mind, right? We're trying to support the development of a skill and mastery of a skill. We're not trying to subdue the will of like an overly rebellious child. That's not the way behavior should be seen if we're looking at it in a special education context. So the law on FBAs, New Jersey and the IDEA both address functional behavior assessments, the evaluation of a student's behavior, and how to address student behaviors in IEPs. So, and I have a couple sites here for you if you want to look at it. New Jersey law requires school districts to conduct FBAs as part of a student's evaluations, either initial evaluations or reevaluations. And this language is in the law, quote, when appropriate. So I would argue that that's appropriate when behavior is an issue for the student, right? Then it becomes appropriate to conduct a behavior assessment. And all evaluation reports, even if it's not an FBA, any of the statement regarding the child's behavior and the relationship of that behavior to their academic functioning. If it's a speech language eval, it's not going to be as in-depth as you need it to address behavioral issues, but it should still be addressed in that report. Law also requires IEP teams, when you're developing the IEP for a student whose behavior impedes their learning, impedes the learning of other students, to include positive behavioral interventions and supports in the IEP. So those are things that should always be discussed. They should always be on the table when you are at an IEP meeting or when you are at an planning meeting and behavior is a concern. So stepping aside from the letter of the law for a moment, best practices. What should an FBA look like? FBAs ideally will be conducted by a BCBA or someone who is equipped to provide the information that we're looking to. So FBAs measure, they're called the ABCs of behavior, lots of letters, right? So A is the antecedent for the behavior because we're looking for triggers. B is the behavior itself. It needs to be very clearly defined. What are we talking about, right? So if we say defiance, that's not defined behavior. We want to try and get as specific as possible. And there can be more than one behavior in an FBA, but you want to define them exactly. And then each type of behavior should have an antecedent, and each type of behavior should then be followed by a consequence. What happens right after this happens? So to be a valid assessment, those are the things that need to be included in the FBA. We want to be especially of what consequences are occurring that actually maintain the behavior that we want to change, and under what conditions is the behavior occur, right? What are our triggers? Weak FBAs. So in an FBA, something that you really need to see in an FBA is to have a behavior described as sudden or random or out of nowhere, or cause cannot be determined, because that's the whole point of the FBA. If the person conducting the FBA cannot determine the cause of the behavior, person conducting the FBA, you might need a longer FBA over several more days. You need to do something different because you need to figure out what's caused is the whole point of the FBA. One thing that I see sometimes is that a child does a behavior because of some internal satisfaction that they get from it, internal stimulus, or being self-determination, or words like that. Again, that's kind of just saying they're doing it because they want to do it, and we're not looking as willful. We're looking at it as a skill, so that's not really going to be very helpful. And when it comes to BIPs, when it comes to the behavior intervention, the goal of the plan is to teach a positive behavior that replaces the maladaptive behavior. But we need that behavior, the good behavior. I'm going to say good and bad. Bear with me. It's just for ease of reference to what I'm talking about. I want the good behavior to serve the same purpose for the child that the bad behavior served. And I'm not a BCB, so I'm talking about this from more of a lawyer's perspective, but this is the general idea here. And then, of course, we want to be able to provide a positive reinforcement for the replacement behavior. So the BIP is the roadmap for how we're going to teach this child appropriate behavior skills. Bad bit. I think someone might be unmuted.
If you're on mute, please, everyone, can you mute yourselves? Thank you.
just because I know I also am, every once in a while, I am also maybe freezing a little bit. And so I just want to try to as smooth a presentation for you guys as I can. So bad BIPs, right? Bad BIPs that are being poorly implemented are going to force the negative behavior. So they're going to do exactly the opposite of what we want them to do. That could be for a lot of different reasons. It could be poorly designed. It could be that the that are in charge of implementing the BIP haven't been trained in how to do it. They don't know how, or they don't have the resources or enough support to do it properly. So let's say caring, well-meaning educator, and they see a child struggling every day in like a math class, so they put their head on the desk and ignore the teacher and they won't do it. Well, let's say that's the behavior we're trying to extinguish. But every time the teacher sees that, she lets the child go to the nurse or to the guidance counselor. She's trying to care for the child's needs and be gentle, maybe, but she's actually reinforcing a negative behavior. So we want to also keep an eye out for that type of thing as well. I'm going to talk about fidelity data. So what am I talking about when I say fidelity data, right? Like we've all heard the word data before, but what does this fidelity data mean? Fidelity data really just means, it's really what all data should be. They are objective measures used by properly with oversight to ensure that data is accurate and consistent. So like I mentioned before, right? Data should never say, if you're behavior chart, that behavior chart is your data. It should never say that a child suddenly threw a chair, right? Or suddenly started screaming, or we couldn't figure out why. That's not accurate data. Data parameters need to be very clearly defined. So if data is being taken on behavior, how much time of the day is data being taken? Is it taken 15 minutes every 2 hours? Is it happening all day long? Is data only being taken for the same half hour every single day? Is it only in one class? Is it only in one setting? Is it only when the student is with one specific adult, right? So who is collecting the data and how often? And then whoever is collecting that data needs to have been trained in how to do it. And really, it's not going to be, so if I assume Old Bridge has some BCBAs on staff or some behaviorists on staff, but a lot of times data collection is being done by paraprofessionals or by a classroom aide or someone maybe by a physical therapist or whatever the case may be. The BCBA really should be overseeing the person who's collecting the data to make sure that it's. And if you can get data collection written into your IEP, go ahead and do it. It doesn't have to be in the IEP in order to in the IEP, but if you can get it written in, that's always a helpful thing to have those parameters set out for the IEP team. I want to talk about prior written notice, right? So let's say you're in an IEP meeting, you're requesting an FBA, and the district is saying, no, we don't think we need that, right? So you're asking for a new evaluation. So when you're asking for that, or let's say you want your child to get a one-to-one para to help them, that's a change in placement, but to be with them throughout the day or something like that, or you want them to start getting counseling 3 times a week with the guide, that's a change in placement. That's a new service. And let's say the district disagrees and they don't feel that it's necessary and they don't feel it's warranted. So what needs to happen is that within a reasonable amount of time, usually it's within 15 meeting, the family needs to receive what's called prior written notice, which is a little bit of a misnomer because you're actually receiving a notice after you've had the conversation with the district. You need to get a written notice of the district's decision and how they reached that decision, including what information they relied on to reach that decision, why they're refusing to change the placement, a description of every assessment and record that they looked at to refuse, a description of all other options that were considered. A lot of you have probably seen this document. It's not always filled out with enough detail to satisfy me or to satisfy the understanding of families who are getting it. But it's a very important document, and you're entitled to written explanations of why a change in placement is either warranted or not. Now, if the district wants to change your child's placement at an IEP meeting and you disagree, that if you get a draft IEP sent to you, a draft IEP is often considered sufficient prior written notice. So you can get that draft IEP and you may not ever get another written document. All right, so let's move on. Let's talk about formal removals and shortened school days. Okay, so this is when you get called to come pick up your kid because they're having a difficult time. They're misbehaving. Maybe they're even in crisis. So we're going to talk about these. What are these? Are these absences? Are these suspensions? Are they nothing? What is this shortened school day? We're going to when those shortened days and informal removals might amount to a change in placement. And if it does mean for your child in terms of their due process rights. And we're going to talk about some suggestions about what parents can do or what you might want to consider thinking about if you're dealing with a lot of phone calls and school removals and things like that. Because it's a very difficult thing. It's a really difficult logistically and emotional thing to have to deal with. So recording informal removals. A school removal is not an absence. It is not the same thing, and it should not be recorded on your child's record as an absence. A school removal by the school, not by the family, and it's in response to the school staff's inability to deal with a student's needs in that moment. They cannot control the behavior. They're at a loss. They don't know what to do, so they call you. Calling someone to pick up your kid early. Writing half days into an IEP is a school removal. Not allowed to attend an event or a field trip because of staff shortages. If you get a phone call, your child's para is absent today, maybe you should keep them home because they're going to have a hard time. That's a school removal. Absences, on the other hand, are decided by the family and without pressure from the school. It might still be because of your child's behavioral struggles. Let's say the child is having a super hard morning and you just can't do it. You just can't get them to school, so let them stay home. That's not a school removal. That is an absence. It's still important to keep track of it and note it because the child still obviously needs some help, but it's not a removal. Oftentimes, these removals are recorded by the school, if recorded at all. A lot of times they're not recorded at all. But if they're recorded as like an early dismissal or an absence or a tardy. Rarely would they ever be considered, like picking up your kid early from school would almost never be considered a suspension. But I suggest that parents try to get it considered suspension. I think it's important to have that record of saying, okay, well, you are saying my child can't be in school right now. What is the length of time of this suspension? When can my child come back? You'll probably get some pushback and a disagreement about calling it a suspension or not, but you should still ask the question and you should ask it in writing. They need to be recorded. So whether the school is willing to call it a suspension or you don't want to call it a suspension or whatever we're calling it, it still needs to be recorded somehow. If you don't know if the school district is recording them or not, A, I would ask. B, I would record them yourself, right? So we want to know a whole bunch of things that are happening right now. We want to know the amount of instructional time being missed. If you are picking up your child a half an hour earlier than every other kid, think how many hours that amounts to over the course of a school year of missed instruction. And keep in mind, it's not like your child just like 2 minutes had a behavior and then they called you, right? It had to escalate to a point where it could have been a half hour or an hour before they even called you, where you're not able to access their education because they were in this distress. So they're missing a lot of time. You want to keep track of that. Also, you can identify patterns, maybe, right? We can identify some of this FBA type data. Sending them home is the consequence, right? And so is that reinforcing a behavior or not, right? Let's keep track of all of that. Informal removals are used repeatedly, and they end up amounting to more days. And your student, your child has an IEP, they are a student with a disability, they are entitled at that point to a manifestation determination review meeting. And we're going to talk about what that type of meeting is. I also want you guys to record what is happening as a result of the removal as well. So you get called. Are you at work? Do you now have to find appropriate childcare? Are you losing pay? Are you missing work? Is it damaging you financially or in your career? Once you get your child home, now you have to get back on the computer for work. So what are they doing? They just have their face in a screen for the rest of the day? Are you unable to engage them in anything more productive than that? For some families, home or kept home from school deprives them of free breakfast and free lunch that they need. And there's also a social and a behavioral and an emotional impact on students as well. So we talked about informal removals. If they're happening for more, if they amount to more than 10 days, they may be amounting to a change in placement that requires there to be a manifestation determination. But the come pick your kid up calls are not addressed in special education law. So it's not written into New Jersey Code or the IDEA. However, federal guidance from the Office of Special Education Programs does state, and this isn't binding law, but it is, it's that partial day exclusions from school count toward a disciplinary change in placement if they are implemented repeatedly. To know. Okay, so it's, I wrote here when they total 10 or more, it's actually more than 10. More than 10. If this happens, the students' due process rights are triggered and they get a manifestation determination review meeting. What is meeting? It is a meeting where a group of informed people come together, the parents, it could be the IEP team, someone who witnessed the behavior. And we have to answer 2 questions. First, was the behavior caused by, or did it have a direct and substantial relationship with disability? Or was the behavior the direct result of the school failing to implement the IEP? Answer to either one of those questions is yes, then the law requires the school district to conduct an FBA, implement a BIP, or if the BIP is already in place, it must be modified to address the behavior. The child has to be returned to their placement where they were, unless the parents agree to a change in placement as part of the BIP. If you answer no to both of those questions, then the child does not have to be returned to their previous placement, but the school keep providing that student with their special education services even when they are at home. We IEPs and specialized instruction missing out on 11 or more days of instruction. So the continue providing their services even if they're not going to be in school at that point. And they have to conduct the FBA and do the BIP. So what do you do when this is happening to your child? This is a really complicated question, and it's circumstances. In some instances, parents have felt comfortable just saying, no, I'm not getting him. I understand that because there is no subclass of children that school districts are not responsible for educating. That doesn't exist. So kids with difficult behaviors still deserve an education, right? So there are other parents that worry that if they refuse to come get their child, not only is that going to be traumatizing for their child, but they are concerned that a call could be placed to the Division of Child Protection and Permanency, what used to be DIFIS, Child Protective Services. And for a family that, well, I mean, any family would want to avoid that, I'm sure. But if you happen to be a family who is already court involved in some way, maybe you really just don't have the tolerance for that risk, right? So it's a really difficult decision to make. I would say whether you get your child or don't, you record what's happening and you have to keep a record of it, because the amount of time, the number of times, and what is happening in response to the behaviors is all it's all really important information to have. Okay, missing out. I'm going to try and keep it brief. I know we're already at half an hour in. Okay, so missing out. So this is when the school takes away access to certain classes or activities as a means of behavior control or as discipline or in response to difficult behaviors, right? So a lot of times we're looking at recess, lunch, and sometimes gym. So special education laws don't explicitly address this concept of forcing a student to miss out on something as a form of behavior control. But what I like to think of it as, first of all, is, if, for instance, an entire class of students, right? Like, let's say an entire LLD class or an entire ABA class is missing out on recess or on lunch because of certain behaviors in the classroom. That's not an individualized response to those children's needs. You're just kind of administering it across the board to an entire class. That's not what IEPs call for. Additionally, look at the students' goals. If there are social goals, emotional goals, those goals are going to be mastered and generalized in these settings that students are missing the opportunity to participate in. That makes no sense. And then we're out of compliance potentially with an IEP. Additionally, Section 504 is a disability discrimination law, and it requires that students with disabilities enjoy equal access to the programming offered by schools. So if children are being denied that access due to their disability, I would argue that that is actually book disability discrimination. And we also want to remember we need to be right to support these decisions, to support the decision that a student isn't going to participate in lunch, right? How does that decision support a positive behavior? To be quite it probably doesn't, right? It probably triggers more inappropriate behaviors, right? So it also kind of, it doesn't, right? Especially if we're looking at behavior in the context of skill as opposed to volition. You don't tell a dyslexic child, if you don't read this, you can't go to recess, because A, it would feel cruel, and B, it makes no sense. There's absolutely no connection. A dyslexic child being given the support to read and taking away their recess. We need to start looking at behavior in a way. New Jersey's recess law. So New Jersey does have a recess law, okay? So students get 20 minutes of recess per day in grades K through 5. That includes half-day kindergarten. Only be denied recess in response to a violation of the student code of conduct. If they violate the student code of conduct, in lieu of recess, they are supposed to be getting what are called restorative justice acts. So they should be doing something designed to improve their behavioral responses, and we're trying to get to a sense of like less punitive interventions, establish a more supportive, inclusive culture. They shouldn't just be like sitting with their head on a desk or sitting watching other kids go out to play. That's not restorative justice. Additionally, if it's a violation of the student code of conduct, the school should be able to point you to exactly violation your child committed. And I would ask for that information as well. And also no more than twice a week. They cannot be denied recess more than twice a week. Unless it's for medical reasons that are mandated by the student's doctor or that are in their 504 plan. There's also a gym law. So if students are missing gym, I would just take a look at it. They're supposed to get 150 minutes per week. Okay, so let's try and, take a look at it and see if they're getting it. I'm going to go through the classroom clears a little bit more quickly. So the state relies on school districts to self-report to determine whether or not they're underreported. So both seclusion and restraint are permitted in New Jersey. They are not permitted in every state, but they are permitted here. Classroom clears are not regulated by law, but experts in this field believe that they tend to be much less traumatizing for everyone involved. The classroom clear is when one student is exhibiting a difficult behavior and it's becoming disruptive to the class. And so the rest of the class is removed from the classroom. Student and school staff are the ones left in the classroom. And the purpose of it is to give the student space to calm down. In New Jersey, this actually is a timeout, which is actually something that's written into the law in New Jersey. So it means it's a behavior management technique. Basically, it means that the student is not locked somewhere. It's not seclusion. And the intent is to down. However, if this is happening to your child, first of all, no one has to tell you. I would like to think that you will be told. And it is data that supports the need for additional or different services for your student. Seclusion is when a child is confined involuntarily and they are physically prevented from leaving that space. So it could be, we've all heard the stories of closets and padded rooms and things like that, but it could just be an empty classroom where they're not allowed to leave. They're closed in and they're not allowed to leave. That's seclusion. It's supposed to be visually monitored because it's dangerous to leave children alone. It does have to be documented in writing in a way that will help the staff develop or improve a BIP at the next IEP meeting. And obviously the law requires us to try to minimize the use of it. What does not required in seclusion, it does not have to be reported to parents. So your child can be secluded and there is no law saying that you must be notified of it. It also doesn't require an immediate revisiting of a BIP. That doesn't have to happen until the next IEP meeting. Restraint. Restraint is similar in the law. So it's the use of restraint that immobilizes or reduces the ability of a student to move their body. A lot of us think of a student being taken down onto the ground. That's restraint. That is definitely restraint. But a student being picked up and carried out of a classroom, I would argue, is also restraint. That child is immobilized. They can't move, right? It's only permitted in an emergency in which the student is exhibiting behavior that places themselves or others in immediate physical danger. You can't do it in the prone position, which means face down, unless authorized by the student's doctor. And staff has to be trained. A lot of times this is CPI training. A lot of times staff has to be trained and they have to be trained once a year. Parents do have to be notified of restraint immediately by phone or email with a full written report within 48 hours. Again, continuous visual monitoring, documented to improve the BIP at the next IEP meeting. It does not, so our law doesn't address the restraint of non-disabled students. So the law requires that families be alerted if their disabled student is restrained, but the law does not require that for non-disabled students. I would like to think that a school would still report it to the parents, even of non-disabled students. I'm sure a lot of school districts make that good decision to do it, but it is something to be aware of. It also, our law does not address chemical or mechanical restraints. Again, that's probably not something that you would come across as often as a physical restraint, but again, it's just something to be aware of. Okay, so what can parents do? So when we're talking about, we talked about removals, the school removals. So we want to be really clear on what is the difference between a school removal and an absence. We want to keep a record of all behaviors, removals, absences, school avoidant behavior, behavior where the student has to miss out on lunch, all of it. We want to keep a record of all of it. If you can keep a calendar at home, anytime you're called to come get your child, sign in at the main office, follow up with an email. I came in today for this reason. How long will my child be kept out of school? Insist on data collection by the school district. Even if they refuse to do it, collect as much of your own as possible. Speak up and let other parents know this is happening. A lot of times, parents of children without disabilities, parents of children without IEPs have no idea what this world can look like for our kids. If you're really in an egregious situation, I would speak to the media about it. We can also talk about how to file state complaints, Office of Civil Rights complaints, or due process petitions as options as well. All right, so that is me. I'm going to stop sharing.
Thank you. And also what parents can do is to get actively involved with their CPAG too.
Their C.
Yeah. So we are going to stop recording now. So I'm just going to stop recording. Thank you for that. Stop recording.